Okay.
Ladies and gentlemen, we have today at the BCLP lecture series probably one of our probably the most distinguished speaker among the many distinguished speakers we've had, Professor George Bermann of Columbia University, who will be lecturing on Twilight Issues in International Arbitration, Latent Choice of Law Challenges. Just a very brief note on Professor Bermann's CV, which is quite illustrious. Professor Bermann is the director of the Center for International Commercial and Investment Arbitration at Columbia Law School. He is a world-renowned authority on comparative law, EU law, international trade contracts, WTO dispute resolution, and transnational litigation and arbitration. For more than 4 decades, he has been an active international arbitrator in commercial and investment disputes in all sectors, including general commercial contract, construction, intellectual property, energy, oil, and gas, competition law, insurance, telecommunications, pharmaceuticals, distributorship and franchising, transportation, and employment. He also serves regularly as an expert witness before international arbitral tribunals, as well as before courts in arbitral-related cases. Professor Bermann joined the Columbia Law School faculty in 1975. He founded both the Columbia Journal of European Law and the European Legal Studies Center, where he serves as the director. In addition to teaching full-time at the law school, he is an affiliated faculty member of the School of Law of Sciences Po in Paris and the MIDS Master's Program in International Dispute Settlement in Geneva. Professor Bermann is the co-author of the UNCITRAL Guide to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, chair of the Global Advisory Board of the New York International Arbitration Center, co-editor in chief of the American Review on International Arbitration, and founding member of the governing body of the ICC Court of Arbitration, and a member of the Standing Committee. He was also the chief reporter for the ALI's international U.S. Law on International Commercial and Investor State Arbitration. So with that very, very abbreviated CV, Professor Bermann, sir, it's a privilege to have you. And as we say here in Miami, we're ready to hear percussion.
Okay, very glad to have this opportunity. I will try to be as direct and succinct as I can, because I don't know your timing, but I have about an hour at our disposal, maybe a little bit more. I expect that's in your range.
Yes, sir.
Okay, well, the topic I'd like to talk about is the subject of a recent book of the title that was just mentioned by Kluwer, Twilight Issues in International Arbitration, Latent Choice of Law Challenges. Now, this needs some explanation because it's not evident what I'm talking about, but I can clear that up, I think, quickly. Both as an arbitrator and as an expert witness, I've become acutely aware of the fact that there are a very large number of recurring issues of a largely procedural character, but not only, arising in international arbitral proceedings, as to which, quite frankly, arbitral tribunals are at sea. They don't know with confidence how to resolve these issues. I'm calling them Twilight Issues, and I'll identify them in a moment. I'm calling them Twilight Issues because I like the sound of that, but primarily because these things do lie on the border of substance and procedure, but above all, we are literally somewhat in the dark on these. So for me, Twilight captures it all. Now, by definition, a Twilight issue is an issue of arbitral procedure or quasi-procedure that is not addressed either in the arbitration agreement or in the law of arbitration, the lex arbitri, or in the rules of procedure that the parties may have adopted in their arbitration agreement. Now, those are our usual sources: the arbitration agreement, the lex arbitri, and the procedural rules, institutional or otherwise. And despite having those three sources, we have issues that are not addressed. And we live in what I call a normative void on these issues. Now, let me illustrate them for you. They are a mixed bag of issues, but they're very plentiful. And the best way to do it is to go through the life cycle of an arbitration and show you when these issues are apt to arise. Now, at the threshold, that is to say, as the arbitration is getting underway, there are, as you all know, a series of issues that are either jurisdictional or admissibility in character. And let me tell you what they include, though you know it all. Did a party waive its right to arbitrate? Is a non-signatory bound by the arbitration agreement? Have the parties satisfied, or has the claimant satisfied preconditions to arbitration? And if not, is its failure to do so excusable? Is the dispute arbitrable? And in investor-state arbitration, it's turning out that we'll have a threshold issue of corruption because, according to many tribunals, an investment procured through corruption is not a protected investment, and it is the tribunal therefore lacks jurisdiction. So I've given you, I think, 5 issues, and none of them is addressed by any of the usual sources of international procedure, international arbitral procedure. Now, when the arbitration gets underway, and we're in the arbitral process, you will not be surprised to hear that what is likely to arise are issues of privilege, of res judicata, of anti-suit injunctions, of the principle of jus novit curia, the tribunal inquires on its own, the use of tribunal secretaries, the sanctioning of counsel, and the drawing of adverse inferences. Now, none of these, I think you'll agree with me, is exotic. They're familiar to us all. We have merits issues, not many, but I'll include them here. One of them, which has received a lot of attention but not much case law, is whether a tribunal may apply the law of a jurisdiction other than the jurisdiction whose law the parties chose. The application of the mandatory law of a jurisdiction whose law the parties didn't choose. And in most jurisdictions around the world, not us, statutes of limitations are substantive in character and linked to the cause of action. And at the end of the arbitration, I've taken you through the life cycle, we have issues about interest that we all struggle with. I'm struggling with it today in an award that I'm drafting, interest, and to some extent costs. Now, it is not impossible for institutions to address these issues. Some of them do address costs. And one that I didn't mention, which would otherwise be a Twilight issue, is interim measures. Our institutional rules are not deaf to those issues. Now, this is not an exhaustive list. This is not an exhaustive list of issues, but I suspect you'll agree with me that they are important, that they are plentiful, and that tribunals are operating without confidence in the law or norms that should be applied to these, which explains some of the difficulties tribunals have, and it explains the frequency with which I personally am called upon as an expert witness. It's remarkable how many of these have been the subject of expert testimony in arbitral proceedings. And that's remarkable when you think about it, because that tribunal is not filled with ignorant people. That tribunal is filled with experienced international arbitrators, and they still are interested in knowing how they should best approach these issues. I've given you about 18 or 20, but they're not exhaustive. Now, let me get to the heart of matters. This is our challenge. Arbitral tribunals do not have forum law. If any of these issues, without exception, if any of these issues came up in a court, that court would be equipped to answer them. There's none of these that isn't addressed by forum law. Just think it through. Just one example. Fora have rules on anti-suit injunctions, when they're proper and when they are improper. And I could go through the entire list, and I won't again, of course, to assure you that the problem arises from the reality that notwithstanding the presence of an arbitration agreement, a lex arbitri, and institutional rules, tribunals are operating in a normative void on these issues. Now, what can we do about it? What are tribunals doing about this? To the extent they are thinking about it with some care. Now, I'm going to go through what I have discovered tribunals doing. None of this is a surprise, but it's good to have documented this. A large number of them, when faced with one or more of these issues, chooses to apply a body of national law for want of anything better. And that immediately raises the question, obviously, of which body of law. Now, the most frequently body of law resorted to is the law of the seat. Okay? There are others. Now, when I say law of the seat, I want to be perfectly clear that I'm not speaking of the law of arbitration of the seat, because the law of arbitration of the seat is obviously applicable. But I've just told you by definition, it has no answers. So when I refer to the law of the seat, I'm talking about the law that courts at the seat apply when these issues arise before them. In other words, tribunals following this methodology are expecting tribunals to piggyback on what courts at the seat do when confronted with these issues. I hope my distinction between the arbitration law of the seat and the law of the seat is different. Actually, Latin helps us here. The law of arbitration is the lex arbitri, and the law at the seat is the lex loci arbitri. So that is a recognized distinction. Now, in a moment, before I go, I want to go through our other options before I illustrate how this source, the law of the seat, can help us. The next obvious candidate is the lex causae, the law governing the merits of the dispute. The third is the law of the place of probable enforcement of an eventual award, if we can predict, which we can't always do, what the place of enforcement would be. And the fourth and final one is a standard choice of law approach, which is select the jurisdiction that has the strongest issue and the strongest interest and the strongest connection with the issue at hand. Now, in a moment, I want to give you some ideas about what Twilight issues are appropriately governed by the law of the seat, and the lex causae, and the law of the place of probable enforcement, and the law of the jurisdiction with the strongest connection or interest in it. But before doing that, I want to mention what our options other than national law are, even though national law is where tribunals really most frequently go. The second is recognition that we don't need an applicable law. I'll give you some examples of that, where we assume that the tribunal need do nothing more than exercise good judgment. And then the normative question doesn't arise. What arises is good judgment. And of course, we're comfortable with that on some issues because arbitrators have been selected by the parties. The parties have confidence in the arbitrator's good judgment, or they wouldn't have appointed them. So we have a little bit greater comfort when it is an international arbitrator than a judge who is using his or her intuition and good judgment about how to address these things. Now, the third one, national law was the first. No need for law is the second. And the third, about which we know little, but we better start thinking of, is the development and emergence of international standards. Because it is more than conceivable that we could have international standards on all of these issues. Now, in the interest of time, we can't go through it comprehensively, but I want to give you some idea of the twilight issues that could plausibly be subjected to the national laws I mentioned, just as a thought exercise here. So let's start with the law of the seat. I've given you 18 or 20 twilight issues, and I'm asking, how comfortable are you in the absence of guidance in simply borrowing the principles that courts apply at the law of the seat? Now, one good way of looking at this is to ask yourself, which, if any, of these twilight issues are ones that, depending on how they are decided, could endanger the award in a court where annulment is sought. I hope I'm being clear. We have the law of the seat. Which twilight issues does the law of the seat speak to? Okay. And there are some of our twilight issues. I'll ask you to think back on them. I won't repeat them. But there's some of our twilight issues that actually very conceivably could lead to the annulment of the award, depending on how they're decided. And the three that I'd like to just give you illustratively are arbitrability, because we know that an award risks annulment at the seat if the seat does not permit arbitration. Non-signatories, that's a no-brainer. And even the question I raised that you may never have encountered of whether a tribunal can apply the law of a jurisdiction the parties didn't choose. On all three of those, there is serious question, serious possibility of an annulment of an award if the wrong answer in the eyes of an annulment court has been given by the tribunal. Now, I don't mean to say that's exhaustive. We could go through the full list of twilight issues and come up with a few others that we think it is not without logic to apply the law of the seat. And we talk about the law governing the merits. That was our second law, the lex causa. Well, now it's not so obvious, but I want to share with you ones that I think a good case can be made for applying the law governing the merits. One of them is the waiver of the right to arbitrate. I'll think about that for a moment. Waiver of contract rights is a matter of substantive law. Okay? It's in a contracts, it's a merits issue. Did a party waive its right to arbitrate? Um, and I think one could, if one isn't simply going to use good judgment, one could say, I think I want to know whether a party waived its right to arbitrate by the law of the contract. By the way, waiver of contract rights is a matter studied in a contracts course. So, if the contract is governed by a particular law, whether the right to invoke an arbitration agreement has been waived is a contract issue. Second, in many, if not most jurisdictions, not the US, the statute of limitations is a merits issue in the civil law world. Third, it is a very strong case to be made for the lex causae to govern arbitrability. Now, I just said the law of the seat could govern arbitrability, but when you think about it, which jurisdiction has the greatest interest in having its arbitrability principles applied? And I think it is the law of the jurisdiction under whose law the claim arises. That is the jurisdiction that has the greatest interest in whether that cause of action is one that may be arbitrated. And though tribunals don't do this, a case can be made for looking to the law of the lex causae on matters of interest if you take the view that interest is a component of full compensation. And those are some Twilight issues that the law of governing the merits makes some sense. When we get to the law of the place of probable enforcement, we know we're back where we were with the law of the seat. We want an enforceable award. So we want to pay attention to whether, if we know the place of probable enforcement, we may want to know what its law is on arbitrability. I want to remind you that the New York Convention has an arbitrability defense. It's Article 5.2a of the New York Convention, and it expressly says that arbitrability is governed by the law of the place where enforcement is sought. For better or for worse, that's what it says. So the law of the place of probable enforcement, if we know it, is something that must be considered if arbitrability is raised. And I'd say the same thing for non-signatory. We all know cases in which an award has been denied enforcement, okay, against a non-signatory on the ground that the non-signatory did not consent to arbitrate. And then finally, the law of the jurisdiction that has the strongest connection. That's a difficult category. One might put in that the law of privilege. But these are just ideas for your consideration. My goal here was not to be exhaustive or encyclopedic, because I can't, but to give you some idea about how we might go about deciding if we're inclined to apply national law, of which national law to look at. So I want to leave that there. But of course, I'd love questions or comments at some point. Now, turning to my second source, which was good judgment of the arbitrators, I think it is true that there really is no real choice of law dimension to some Twilight issues. And my best example for you is the drawing of adverse inferences. That was one of my Twilight issues. How does a tribunal go about determining whether A, it is appropriate to draw an adverse inference, and B, how to go about deciding what inference to draw. Now, I honestly believe, as much as you love conflict of laws, as I do, as much as you love it, we're not going to look to a body of law to make that determination. I'm sure of that. Similarly, if, as in the BG Group case, which is a perfect illustration of this, we had a failure to satisfy conditions precedent, and the question was whether that failure, which was admitted, was excusable. Does one have a justification for not complying with a condition precedent to arbitration? And I'd say, I don't think we want to bother searching for a rule of law on that, though, of course, we could if we're inclined to. Sanctioning counsel. I mean, we may start getting some soft law on that, but again, tribunals are very largely using good judgment, quite frankly. Now, I want to get to the really interesting possibility, which is, do we want, and is it worth exploring the idea of international standards on these issues? And another way of putting it is, are we comfortable with applying national law? Are we comfortable with applying no law? Think about that. Are we comfortable applying the law of one of the 4 jurisdictions I alluded to? Are we comfortable, or how comfortable are we in just letting the tribunal do what it thinks best? By the way, I should tell you, when I launched this project, one of my very best friends, I won't name him, who is someone you all know and was a classmate of mine and friendship going way back, said, "You're crazy. You're crazy. We're choosing smart arbitrators. You're wasting your time." Okay, so, that's a position one could take, that what I'm doing is pointless. But obviously, I don't think it's pointless. Maybe that's because I'm a professor, but I don't think it's pointless to ask these questions. So, international standards. Now, by the way, we're seeing them, so I'm not making this up. And the only question before us is, how fertile do we think this prospect is? Now, we should start with a definition, for better or for worse. I think we would probably end up saying that an international standard has emerged if a consensus has emerged. Now, consensus doesn't mean unanimity. I think we know that. But we have to say to ourselves, before we say, I've come across an international standard, is it widely enough subscribed to by informed people that we should acknowledge that an international standard has arisen? Now, once you start talking about international standards, there are all kinds of questions that are raised. But the one I want to focus on in the time that remains is, how do we ascertain that they exist? And ascertaining that an international standard exists is something that a tribunal would probably engage in before purporting to apply an international standard. Now, the next question is, if international standards is the normative source, what are the normative sources of international standards? Where do we get them? Now, we are observing a trend toward this, and we are observing where tribunals are finding international standards, where they are, what they're drawing upon. And I have 4 categories for you, and I won't take you through it, but I have illustrations to suggest that an international standard is emerging on some, not all, of the Twilight issues I mentioned. Now, I have 4 sources for you that I have observed being relied upon by tribunals. One of them, none will surprise you, but one of them is soft law. Now, international arbitration is awash in soft law. And there's a very strong case for saying that soft law, once it has emerged, is an important source of an international standard. Let's think of it for a moment. Soft law is the product of deliberation, often long-term deliberation, among knowledgeable people. It's an iterative process, as you know, highly iterative. Go through drafts, they go through comments. And better yet, soft law is, what shall I say? It's ready-made for application. That's what it is. So it's something that we've thought about. It's something that has been the subject of deliberation. And we have soft law, and we have, I think, some international standards that draw upon soft law. Let me give you a couple of those before I move on to other sources. We have soft law on the question of res judicata. The International Law Association, the ILA, has actually produced a report, recommendations, and a report on res judicata and also collateral estoppel or issue preclusion. Now, we have soft law, I think you know. You may not find it adequate, but we have soft law on discovery. Now, that wasn't one of my Twilight issues because I don't think we're in a normative void there. But soft law has real prospects here. And luckily, we have IBA, ILA, bar associations that are embarked on this. I know that there is a backlash against soft law. There are people who have written extensively that we have too much, and soft law is inimical to the flexibility prized in arbitration. We don't really have time to have that debate right now, but I think that's an overstated attack on soft law, and I could give you my reasons, but I won't. There are some Twilight issues where we can never expect soft law. And my best example, the clearest example, is arbitrability. Every jurisdiction is going to decide for itself what it deems to be an arbitrable dispute and not an arbitrable dispute. I focused on soft law, but I want to point out that arbitral institutions are issuing notes of guidance to arbitrators. And they are, in their own way, soft law. They're not binding. They're not binding, but they are advisable. And they can function in the way soft law functions. And here we have some really good examples. The best one being the use of tribunal secretaries, where the institutions many of them have issued notes, not rules, but notes on the proper and improper use of tribunal secretaries. So that's all by way of soft law, broadly construed. What I hope I'm convincing you of is that at least some of my Twilight issues are candidates for international standards. Now, the second source, as you might expect, is arbitral jurisprudence. And arbitrators do, of course, when they resolve Twilight issues, commonly look at what other tribunals have done. And if what other tribunals have done reaches a sufficiently critical mass then we're on the road to an international standard. Some of the Twilight issues are the subject of arbitral jurisprudence, express arbitral jurisprudence. Res judicata is one of them. Treatment of conditions precedent is another one of them. And even non-signatories is another one of them. So if we get a critical mass of awards, and there is a consistency that emerges, we may have some comfort in saying an international standard has emerged. I do want to acknowledge that some of my Twilight issues will not be addressed in the award. So we have to be conscious of that. Some will be addressed in the award. Res judicata obviously will be, if it's granted or denied, correct? It will be part of the award. But I have two Twilight issues where the awards won't tell us what happened. One of them is the use of tribunal secretaries, and the other one is use novit curia. Tribunal may engage in use novit curia, but that won't really surface in the award itself. Now, I told you what some of the advantages of soft law are. I told you they're ready-made for application, and they're the product of a deliberative, iterative process. With arbitral jurisprudence, we have some difficulties. Obviously, confidentiality of awards is a difficult one. What's interesting is that arbitral jurisprudence in investor-state arbitration has advanced very seriously, and that can be correlated to the availability of awards. All right. So, just an example: did the investor exhaust remedies? Okay, and we're going to have that addressed, and the investor-state awards will be in the public domain. But a tribunal that takes this seriously will have to do some research. There's more research to be done here than there is with soft law, which we can just pull off the shelf. Now, a third source of international standards is actually international law itself. But upon closer inquiry, there aren't many of my Twilight issues that international law addresses. Customary international law is about what states can and cannot do. Okay, the target are states. Very relevant in investor-state arbitration, not so much in commercial arbitration. But another source of international law is what the statute of the ICJ calls general principles of law. General principles of law. And that means principles that are widely subscribed to by jurisdictions around the world. If you were interested in what issues fall within the category of general principles of law, you will find very few Twilight issues. You'll find things like the principle of good faith, pacta sunt servanda, the principle of clean hands, the requirement to mitigate damages, and so on and so forth. So it's not clear to me that international law will be as fertile a source as we might think, but a couple of examples where it might be include, once again, res judicata, and maybe even lis pendens. Now, finally, and this is, of course, very interesting to me, as a source of international standards, we can look to scholarship, but also to professional commentary. I don't have to remind you about how often we'll gather at a conference and somebody is going to talk about a Twilight issue. I've been to many of them. Someone's going to talk about non-signatories, okay? Someone's going to talk about any of these. And you know, that is a way in which ideas are diffused and get adopted by non-signatories, how costs should be allocated, interest rates, use of tribunal secretaries, once again. As for scholarship, well, scholarship can advance this process, obviously, as well, not only by coming up with ideas, but synthesizing and diffusing the ideas that have arisen. So I don't know if you're intrigued by the prospect of international arbitration acquiring international standards. But if you are, then the real good question is, to what extent, having made international standards depend on a consensus, should a tribunal feel free to embark on an international standard without it yet having achieved a consensus? It's an interesting question. If we know there's a consensus, that is fine. But how comfortable are we in tribunals saying to themselves, in effect, I have no applicable law, I have no applicable norm, I don't yet have an international standard defined as consensus, but I want to create one. I want to contribute to one. That international standard could be embryonic. It could be simply embryonic. It could be somewhere on the distant horizon. It's a work in progress. And so a really good question, I think, is to what extent should arbitrators feel free in a normative void to lay the foundation for an international standard? Now, you may be surprised to know that I'm very comfortable with that, because international standards do not fall from the sky. They start somewhere. They start somewhere, and we probably shouldn't have to wait until we have soft law for a tribunal to apply what it thinks is a sound, if embryonic, standard. Now, I need to close by just a word of caution about all of this, about international standards. We may be very attracted to the idea of them, but we, of course, mustn't ignore national law. We must be aware that national law may impose demands that are not satisfied by an international standard that we come up with. A little bit of a detour here, a tangent, is to tell you that Andres Llana, who you might know from Chile, and I headed a task force for the ICC on streamlining the award production process for small and medium enterprises. And one of the things we encountered, to our surprise, was that some of the things that we were recommending were frowned upon by national law. For example, we imagined abandoning the requirement of reasons. And then we discovered there are a scattering of jurisdictions out there that demand that awards be reasoned and do not consider that requirement to be waivable. So in our infatuation, if we are infatuated with international standards, we have to remember that ultimately the arbitration agreement, the arbitral procedure, and the arbitral award are going to make their way into a national court. And a national court may have boundaries. I should mention the restatement here, which we spent 12 years on, but the restatement blew us away as to how many issues in arbitration are coming before courts. And so we can't be ignorant of that. And the second caution would be for a tribunal, thinking of being adventurous here, is some attention should be given to what the legitimate expectations of the parties were. Because it's all well and good for a tribunal to decide to promote the emergence of an international standard, but that international standard may be so embryonic that expectations have been built that would be disappointed if they were applied. So that really brings me to the end of the inquiry. I hope you don't think it's pointless. I want to emphasize that I approach this not simply because I like conflict of laws, which I do and teach in my transnational litigation course, but because, once again, as an arbitrator and as an expert, these are issues that are not as, it's not as clear in what direction tribunals should go. And I should add that if tribunals are uncertain, then counsel have to be uncertain as well. So I'm not only addressing arbitrators. I think this enterprise is of value to counsel, because counsel may find that one or another of these normative sources is more decidedly advantageous to his or her client, and has an interest in making this inquiry. So this is what I have come up with. I just thought these issues are too important, they're too numerous, and they're too recurrent to be left the way they are, and for us not to know what to do. You can decide for yourself, obviously, whether you are wedded to using national law because it exists, unlike international standards. You might be wedded to national law because it exists out there. You may say that there are more Twilight issues than I have mentioned that should be left to good judgment. I used adverse inferences and excuses for not satisfying preconditions to arbitration, but you may say some of these others we should leave to the best judgment. And then we have international standards, and you decide for yourself. I've decided for myself that if an international standard can responsibly be applied, or responsibly be begun, that we should do that. The takeaway from all of this is that this is a very mixed bag. It's a very mixed bag of issues. And as is so often the case, no one size fits all, which underscores my effort to somehow match them with normative sources, and which is what we basically did together today, do some matching of them. As I told you, I'm struggling right now, today, with an interest question. I don't want to bore you with it, but it's an investment law, actually, of Kosovo, the Kosovo investment law, not a bit. And that law actually prescribes that interest shall be based on LIBOR plus 2. Now, LIBOR has gone out of existence. And what are we doing about that? And I had to do some research, and I came up with something But this has been a struggle. We had to decide whether we should apply LIBOR for interest up until the point in which LIBOR was terminated. And then at that point, apply a different standard, or whether we should apply the new standard to the entirety of the interest claim. I'm just trying to tell you how, if you don't already know, how complicated some of these Twilight issues are. And I believe that we should try to do the best we can. We should feel that the award we rendered, not only on the merits, but also on these issues of process, that they were handled in the most sensible and principled way. And that's my preoccupation in this study. So I think I've shared it with you to the fullest extent you would be interested in. Actually, I'd be very happy if there were any comments or questions about it, though it has been the subject of a number of events, including last Paris Arbitration Week. And so I know a good deal about how it's going over, but it's always good to know more. So I hope you found this of some interest. I'm being autobiographical right now. I seek as a full-time professor and frankly, a full-time arbitrator to bridge the gap between the academic in international arbitration and the practical. And so I'm unlikely to write an article or do a book on evidence in arbitration or the art of cross-examination or something like that. I mean, I'm really striving to find something that critically combines the academic and without fail, the practical. And I think this is a project of that character. And so I'll stop there. And as I said, hope this has been of some interest.